Hey you guys, your legal bestie here, and I hope you guys have been enjoying the channel thus far. I really enjoy getting the opportunity to help young entrepreneurs become serial entrepreneurs, but more importantly, become empire builders and legacy owners. And we do that by making sure we understand the do's and don'ts and the importance of protecting our legal legacies. Today's video, we're going to be talking about none other than trademarks. I love trademarks because literally there is no successful billion-dollar business in the world that does not have their trademark. So if you know that creating an empire, growing a legacy is something that you want to do through business, owning your intellectual property is key to that formula success. But one of the things that I've noticed in being a corporate attorney for years before I started my own practice is that when I would get along amongst the table to start negotiating with creatives, especially creatives that looked like me or that were women, they were novice and they didn't have any wise counsel explaining to them on their behalf the importance of why they needed to make sure that they were coming to the table with their brands already protected and secured. So the very first thing that I want you guys to do if you're considering starting a business or you already have one and you're kind of just starting to get your legal eagle eyes on your stuff, I want you to first and foremost do a USPTO search. This is the United States Patent and Trademark Office. They give you the opportunity to search their entire trademark database to see what else is already out there in particular categories to make sure that you're not already or will in the future infringe on another business. This is going to be critical because what I see a lot of times is that people will come up with a cool catchy name, they'll notice that it's available on Instagram, or they'll notice that it's available on a GoDaddy URL and they'll secure it and they'll think, hey, I must own this because I own the domain, I have the social medias. Wrong. That couldn't be farther from the truth. That just gives you an address on the internet. But actually owning your trademark is going to limit and stop other individuals, regardless of where they live in the country, from being able to use your brand in a similar or same classification. This is critical. This is the reason why you can have a Delta Airlines and a Delta Faucets, because one is in home improvement and one is in airline. But if somebody else wanted to come in and start a new airline and they wanted to call it Delta Sigma Theta, because why not? They wouldn't be able to because Delta already owns Delta in that space of airline classification. So you want to make sure that you do your due diligence before you start putting a ton of money into your brand. So now that you've done your search and you realize that it's available, you have to be asking yourself, Attorney Price, can I go ahead and file this trademark on my own, or do I need to go ahead and hire you? And honestly, it's going to depend on your ability to sit and learn a new system, learn new language, and put your legal hat on. I'm never going to say filing a trademark is something that you should not do, but it is something that I'm going to encourage that if you have the resources, that you do actually hire out and get someone to help you. The main reasons why I suggest you get someone to help you file your trademark are two main reasons. The first being is that 90% of applicants who don't use an attorney and file on their own end up filing in the wrong classification and their trademark gets denied. Second, if you do file it correctly and there's still some nuances that need to be touched on, you'll end up getting an offshot. You guys, I'm getting way ahead of myself. I'm telling you the do's and don'ts of filing when I haven't even broken down how you can file on your own if you choose to. So first and foremost, I've already told you how you can go ahead and do your own USPTO search. Next, let's go ahead and start talking about how you can actually protect your trademark on your own if you wanted to. And then you be the judge if it's something that might be a little bit over your head. So the very first thing that you're going to do when you're filing a trademark, you're going to go, like I said before, to the uspto.gov, and you are going to open a new trademark application. You're going to go onto the link, click it. It's going to ask you your basic information like your name or your entity name. Quick caveat here, you guys, a lot of people ask me, do I have to file my trademark under my business name or my personal name? And the question is, who do you want to own the brand? Do you want your business to own it, or do you want to own it personally and then license it back to the business? This is something I counsel my clients on so that we can really determine what their larger scope and view is envisioned for the business itself. Once you put in all of your personal and business information, then you go to the next screen where you will put in the information about your mark. Again, you guys, we're just talking about standard marks. So think of the business name Nike or the business name McDonald's or the business name Nordstrom's. We're not talking about the Nike swoosh. We're not talking about the Nordstrom's or the Microsoft emblem. We are literally just talking about their business names. We can discuss filing a logo or design trademark in the next video. But you're gonna go ahead and put in the business name. And on the second screen, this is where things can get a little bit tricky. This is where you're gonna actually choose what classification that you're doing business under. There are literally so many, but do your due diligence, take a step back. You can also go to the USPTO.gov, click on the quick links, and you can look at all of the classifications that there are so that you can kind of determine where you might fall under, because a lot of time businesses can actually fall under multiple classifications. This is the reason why you have a company like Pepsi that has hundreds of trademarks under their belt. But now that you've picked your classification, then you're going to put in if there's any type of disclaimers that need to be put into the actual trademark. From there, you're going to put in some very, very minimal information about the actual mark itself, such as when did you actually form it, when did you actually start selling, and then last but not least, you're going to put in if you're filing an intent to use application, which means, hey, I haven't launched this yet, then you'll just go ahead, you'll pay and you'll move on. But if you're filing an in-use application, you'll actually have to take, this is where you actually tell the USPTO that you're using it. So you'll upload evidence showing that you're using it in commerce, and then from there you click submit. I know that that sounds easy and boom, 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 piece of cake, but the full trademark process actually can take anywhere from 8 to 16 months, meaning there's a lot of nuances that happen in between. So once your actual application is submitted in the air to the electronic filing system, it takes literally anywhere from 3 to 5 months just for it to get assigned to a trademark attorney. Once it's actually assigned to a trademark attorney, they do their due diligence to see if it's going to infringe on any current trademarks. They also just double check to make sure that you did your application correctly. This is where office actions can come into place, because anything that the examining attorney sees could be an issue or needs to be tweaked, they formalize that through an office action. And like I said before at the beginning of the video, one of the number 2 reasons why people who file their trademarks on their own end up losing them is because they don't properly answer or file their response to office actions in a timely manner. This is that key piece. So once the examining attorney reviews it, they'll send potentially an office action that needs to be answered within 6 months. Once that's answered, and if it's approved, then the examining attorney will review it one last time, and then it's submitted for publication. This is where things can get a little bit wonky. Publication in the USPTO Gazette, it's basically like a large newsletter for businesses to be able to look and see what other new trademarks are getting ready to be filed. But it's other businesses' opportunity to say, hey, ooh, shock, there might be a brand that's getting ready to come on the scene and infringe upon us, and the examining attorney didn't catch it, so this is their opportunity to oppose your ability to register your trademark. So the USPTO gives everyone a certain amount of time to be able to oppose your mark. If your mark is actually opposed, you enter into an entire different system, which is the trial board, where you will actually, it's literally like a virtual court case where you will argue the depths of if you should be able to move forward with your registration, or if that company has some legitimate teeth in saying that you're going to infringe upon them. If you don't get any type of oppositions, then you're good. It'll go through one more review and you're moved on to the actual registration process. But if you are flagged during that process of getting an opposition, you go off into the trial and appeals board to fight that, and that can take literally a whole other year. But if you're successful through that opposition, then your application is actually approved and you are officially a registered trademark owner. So I know that process may sound like it may not be that hard, but I promise you guys, I've been doing this for over 8 years, so I can do this like clockwork. But for those that are very new to the space, it can get a little daunting, and I don't want you guys to get in the place where you're actually spending money in filing fees to do this on your own, only to either file it incorrectly or to get an office action and then have to hire an attorney. And most times when you bring in an attorney at that later date of needing them them to come in on an office action or an opposition, or there's an issue with the application, they actually can sometimes even charge you more than what they would have charged you to do the initial application. So you end up actually spending more and more time, and potentially lose out on deals because you don't have your ducks in a row. So I hope this video was super helpful. If you have any questions, sound off in the comments. Let me know what questions you guys have about trademarks, about trademark filing, about protecting your brand, about being a boss and growing an empire, or how you can protect your legal legacy. I'm your legal bestie, Dominique Attorney Price. And I really hope that this information was helpful, because again, you guys, I do this because I've been on those other sides of negotiating tables, and I know that we don't know the information that we need to know. But unfortunately, ignorance isn't a legal defense. So I want to make sure that you guys are tapping in, you guys are getting this information, because I promise you it is going to feed you and be able to help you grow empires for generations to come. So you guys, until the next video, make sure that you like and subscribe.